Good afternoon, everyone. How many people have been to a GDPR event before? Raise your hands. Quite a few. How many people have got some sort of GDPR program in place within their organisations to change some processes and look at compliance within your businesses? Just a handful. Okay, great. So what we thought we'd do today is we thought we'd give quite a general overview to the new regulations, why we think they're important, and give you some hints and tips as to areas we think you should consider and evaluate within your organisations. And Lydia's going to take you through Close Brothers' journey and look at this very practically in terms of the steps that you can take on the journey. I want to start by saying I'm not here to scaremonger, and obviously neither is Lydia or Close Brothers. There's a lot of information about GDPR out there. There's a lot of very good, very valid and very informative material. There's also another category that I think raises some alarm bells with some people and might not necessarily be strictly true. This is a new piece of legislation that's coming in. We all need to pay attention to it. We all need to do some evaluation of our businesses, and we'll all need to take some steps towards additional compliance measures. But this isn't, like an Armageddon, and this isn't meant to be a huge change or a huge shift. It's very much meant to be a step on from the Data Protection Act and a step on from current data protection rules and regulations. The problem for some organisations is that maybe data hasn't been at the forefront of their planning, or maybe hasn't been given internally enough of a limelight and consideration. So for some organisations there's slightly more to do than for others, but hopefully by the end of today we'll have given you some tools and information to enable you to start that journey if you haven't already started. So GDPR is a piece of European regulation, and what it means, because it's a regulation, is that it takes direct effect in the United Kingdom and every other member state in Europe. So the UK courts do not need to pass in Parliament any additional legislation to bring this into force. And that's quite important, because what's meant to happen is this should drive consistency across the European Union, because we've all got the same singular piece of legislation to work from. So if you have clients who are outside of the United Kingdom in another EU state, you don't have to grapple with differing requirements in terms of data protection and GDPR going forward. There are what we call derogations, and there's 51 of those. So there's 51 aspects where local legislatures can make decisions on some points. The key one, which probably isn't overly relevant in this room, is around what age someone would cease to be a child. So that's one derogation, and we haven't as yet had clear guidance as to what the UK are going to set as the age that someone will legally become an adult. It will be somewhere between 13 and 16. Can't do any presentation without mentioning Brexit, can you? For those of you sat there going, well, she's already said it's a piece of EU regulation and, well, we're leaving, so why are we even here and why is everyone still talking about this? There has been a very clear steer from the ICO, which is the Information Commissioner's Officer, the data protection regulator in the UK, but also Parliament, that they will be bringing into force GDPR, and that there is, Brexit is a little bit of a red herring when it comes to this piece of legislation. So it definitely isn't something you can set aside because Brexit is going to be happening. Irrespective of Brexit, the legislation has what we call extraterritorial reach, which means that companies, organisations, data controllers based outside of Europe still need to comply with this legislation if they process data that identifies a European Union citizen. And this is a key change from a data protection perspective, and it's a key benefit for everybody sat in this room, because at the moment the Data Protection Act doesn't have extraterritorial reach. So we've struggled with the likes of Google, Amazon, Microsoft, who aren't headquartered within Europe, to get them to take our data protection requirements seriously. And there's been a huge shift over the last couple of years where these organisations have been forced to take account to what our requirements are under GDPR. And so we've seen more of a worldwide shift in data protection and data compliance, which is a benefit to everybody in this room. The timescales, for those of you who don't know, is that the implementation deadline is the 25th of May 2018, and it's from that date that we will be all held up to the requirements of GDPR as opposed to the current Data Protection Act regime. We've had, believe it or not, a 2-year implementation period, and then before then we've had multiple years where there's been drafts of this legislation and lots of commentary. So the time really is ticking now, that we're literally, I think someone told me it's about 17 or 16 weeks away from the 25th of May. And what is still frustrating for the likes of Lydia and I, and I'm sure most of you, is that we don't have all of the guidance from the ICO yet around this legislation. So we appreciate how much of a nightmare that is, but we are all in the same boat. So the ICO are well aware that they've been very slow in issuing the guidance. Most of it's still out there in draft, and they've made a very clear statement that even though it's in draft, they still expect you to be working towards that draft guidance, and just because they haven't finalised it won't mean that they'll be lenient with you if you haven't followed their requirements by the 25th of May. We'll have to wait and see how they manage that after the 25th of May, but they have been very clear in their blogs and public statements about that. So I'd urge you to still look at the guidance, even though it's in draft, and start planning for those changes. And we'll talk a little bit more about the guidance in a second. The reason most people are giving this a lot of attention is the increase in penalties, and particularly the fines. So under the Data Protection Act today, the greatest fine the Information Commission officer can levy is £500,000. The top end and the highest scale of fees under GDPR is the greater of €20 million, or 4% of global annual turnover, whichever is the higher. So €20 million or 4%. So that's obviously a considerable increase from the position we're at today. So back to the we're not here to scaremonger position, the ICO have published a blog about these increased fines. And what they've said is they are not, despite some press coverage that has already been out there, they're not going to be scaling up. So if they might give someone a £400,000 fine today, which is 4/5 of their fining ability, they won't, as of the 25th of May, be looking at 4/5 of €20 million. It's not going to be, as simple as that. They still say they're going to be proportionate. So they still say that they're going to look at all of the factors when they're looking at fines, including the size of organisations. But there is no clear carve-out, or there's no sort of lower thresholds depending upon what your size of your business is, or if you've got clients who might be in the not-for-profit sector. So if they're not-for-profit, they don't have the 4% of global annual turnover threat, but they've got that €20 million threat, which obviously is very considerable. So this is why it's getting an awful lot of attention, and we'll just have to wait and see what the fines do indeed look like as of May. There are, of course, other ramifications for if you don't comply with the requirements of GDPR. They can still make enforcement orders. You could still be audited. There are criminal sanctions in some limited cases where individuals are negligent and don't give any due attention to the rules and regulations. So the fines are just one aspect. Then it is important to remember that. Actually, if you have a data breach, it's the PR damage really that's going to be more damaging, and the reputational impact rather than the actual fine. And we've seen recently some quite surprising positioning on fines. So we're based in Newcastle upon Tyne, and I'm not sure if you saw in the national press, but Newcastle City Council had a very significant data breach. They emailed a list of newly adoptive parents to invite them to a lovely summer barbecue to help them, network with other people in a similar position. Unfortunately, they sent that invitation to a lot of people they shouldn't have sent it to, and they attached a spreadsheet that contained child's original name, child's original parents, child's original address, child's new name. These were children who weren't given up for adoption. They'd been forcibly removed from their birth parents. New parents' names and addresses. So this was a very considerable breach that put at risk a number of children and their new parents. So it made the press exceptionally quickly, not quite sure how, and obviously the ICO were involved. The ICO announced between Christmas and New Year that there would be no fine for Newcastle City Council. They said because it is down to human error, and with the most robust GDPR or Data Protection Act compliance procedures in place, there will always be an element of human error. So I think on the one hand, that's exceptionally reassuring because whilst you can try your best, human error will always and can always occur. On the other side, I disagree that they had done everything appropriate regarding that information, because I think it is totally inappropriate that there is a spreadsheet with all of that information on internally, never mind externally, that doesn't at the very least have a password on it. Because, you know, Excel, or I think it was an Excel document, that's a piece of free functionality to add a password to it. I'm not talking about expensive encryption or techniques like that. So it is worth thinking and evaluating in your organisations, your processes, and if there's anything you can do, like passwording and making use of tools that are free or within your existing software packages to improve the access rights to your data. I should say the individual at Newcastle City Council who sent the email resigned with immediate effect. And that may have assisted with the ICO decision making, although obviously that poor individual who sent that email will probably, you know, never forget that day. And hopefully that won't happen to any employee in any of your organisations, but human error will still happen. So the first key player when we talk about data protection really is the data controllers. And for those of you who might not be overly familiar with this type of terminology, the data controller is really the data owner. So Muckle LLP, my employer, is a data controller of all of their employee information. So all the stuff they have on me, they're a data controller. They own that. They determine what purpose it's used for within the boundaries of the rules and regulations. You will be a data controller of your client information that you put within your sort of CRM databases and all of your supplier information as well. You capture that information, you own it, you control it. And under the current Data Protection Act, they only care about controllers, and all responsibility is on controllers only to deal with, handle, and make sure that information is kept safe and secure. And when you are acting as a data controller, there's not that much really that's changed in relation to GDPR. The rights that individuals have extended slightly, but the obligations on you are pretty much the same with only a few additions. So one of the key additions is that you must have written agreements with all of your data processors. We're going to talk in a second about data processors and who they might be. And they have to contain some specific provisions, and there is an ICO guidance note on this, and there's a really useful checklist that you can go through. So you need to be identifying all of your data processors and making sure you've got control over them is one of the key things to do. So a data processor is someone who acts on the data controller's behalf. So it would be people like an outsourced payroll provider, a hosting provider of your software. If you were to outsource call generation, lead generation, those types of individuals would be, or organisations would be your data processors. They're organisations whom you give information to that you control and you determine the purpose of processing for, and you direct them to do a particular job for you and then to normally send you back the data or delete it. So the good news is that data processors now have direct requirements under GDPR. So all of the requirements that have previously just been put on controllers are also being put onto data processors in the main. Bad news if you're a data processor is that your risk profile has just gone through the roof, because before you needed to be relatively data protection savvy in order to win your clients, because obviously they needed to trust you, with your data, with their data, but you would never get fined and there wouldn't be that scrutiny on you. But that is the fundamental shift now, that both processors and controllers have requirements, and both of them will be looked at should there be any problems with that particular processing activity. So one of the key things you should do is make sure you identify when you, as an organisation, might act as a processor. So if your clients are giving you their data for a particular reason, if they're giving you their employee information or anything like that, you may be their processor. And equally, to make sure you know who all of your processors are, to make sure you can get those contracts in place and hold them to account. You still have that obligation, so you should be doing due diligence before you onboard any new data processors to check them out and make sure part of that due diligence includes looking at their data protection regime as well. Controllers and processors have a new requirement to document their processing. Now, if you have 250 or more employees, you have to document all of your processing. And there is an example spreadsheet on the ICO website that's a nice Excel document with an example tab that shows you how to do that. That's quite an onerous task. If you have less than 250 employees, the good news is you don't have to document all of your processing, but the bad news is that you still have to document processing activities that are not occasional and could result in the risk to the rights and freedoms of individuals. I'm struggling, if I'm honest, to think of any regular processing that might not result in a risk to the rights and freedoms of individuals. So I still think that's quite a wide obligation. And you definitely have to do anything where you are processing, so you have to document all your processing of special categories of data or criminal convictions and offences. So special categories of data is things like race, religious belief, sexual orientation, medical information. So that's a sort of a higher category, if you like, of personal data that they require you to have higher thresholds and a greater control and processes in place. So this is quite an onerous obligation, and these spreadsheets only came out from the ICO in December, which from my perspective is pretty flipping late because I've already started doing this with a lot of my clients already. So if you haven't done that, it's worth logging onto the ICO website and having a look at that information. I'll show you in a minute where you can get the majority of the information off the ICO's website from. And for those of you that might have started data mapping, that probably overlaps this to a degree, but it's still worth looking at the example spreadsheets to make sure you've got all of that information captured. So the key thing is around protecting data subjects. So that's like you and I. And a data subject is any living individual. So all data subjects have the rights that I've put up there on the screen for you now. So the first is the right of erasure and the right to be forgotten. And this has come about mainly through the use of Google and news archives and things like that. So there was lots of cases whereby individuals who might have had something incorrectly quoted about them in the news papers might then have had a redaction and a formal apology. But if you put their name into Google, it's not the formal apology that pops up, it's the original newsreel, which obviously they get a lot of distress and potentially damage caused to them because of that. So that was really the catalyst for this kind of new express right. So individuals have a right to be forgotten and for their information to be erased. I think it might have been at the last event I did with Lydia that we had someone in the audience put their hand up, and they were from an organisation that bought debt and managed that debt and obviously tried to recover it, and they'd had an individual write in and say, I exercise my right to be forgotten, delete all of my information, which includes my debt. Well, that is not going to happen. So the right to be forgotten does not override things like that. So what you need to be really clear about internally is why you hold certain information and what's your lawful basis to process that. They had a very clear lawful basis on which to process that information, and unfortunately you can't just say, I don't want you to chase me for that debt, so I'm going to use GDPR to trounce that. GDPR does not override any other piece of existing legislation. So if you've got a legal right under a different piece of legislation to keep a piece of information, you do not need to delete that information at the point in time that they ask you. But what you should be doing is saying, I'm not going to delete these particular records that we have because this is the basis on which we maintain them, and this is when we will delete them, because you should always have a data retention and deletion program in place for any piece of information, not just because somebody might ask for it to be deleted. So if I was to leave Muckle, which I'm not intending to do, I should say that, my boss is sat in the corner, but you know, if an ex-employee leaves, they might contact you and say, forget all about me. So it would be, you know, reasonable for my information to be taken off the Muckle website, because if I'm not there anymore, they shouldn't have it on the website. But they need to keep payroll records, so they need to keep records from an HMRC perspective that I was employed there. There's certain insurance requirements. They're not going to delete every single client file I ever worked on to remove my name from the email system. That's just not appropriate. So you should think about your organisations and the different types of people who might write to you and say, forget me. And think about how you can manage that, and when you will forget someone and when you won't forget someone, and then be able to justify that category where you're not going to delete everything right now, but you'll need to explain when you're going to do that deletion. And there's a right to object to profiling. This is quite a complex area, and this is the The sorts of things this is looking at is, I'm sure you'll have seen in the press, the tragic situation with the charities where a donor committed suicide because they were hounded by certain charity call centres for donations because her information had been profiled, as probably most of us in the room have been profiled by charities. They're looking for people who have a propensity to donate. They're then looking at that, or they were looking at that alongside trying to get people's dates of birth, health records, understand when people might be likely to make a will. So if you were pregnant, lots of pregnant people make a will ready for their, or expectant fathers as well. So they were taking health records where you might sign up for these sort of free pregnancy things, and suddenly you get bombarded with information about making charitable donations in your wills. They're doing that by getting lots of different document sources and pulling them together to get a profile on you, and in that case, a propensity for when you might donate or make provision for donations in wills. It happens all of the time. I'm sure when you're on websites and things like that, I sometimes get very confused as to how, when I'm on the Daily Mail, I'm going to admit that now, the Daily Mail website, and they suddenly pop up with the last thing I might have looked at on a shopping website but decided not to leave in a cart. That's due to obviously cookies traffic, but it's also because they are propensity modelling me and profiling me as to what time of day I am more likely to internet shop. In my lunch hour, that's probably when they're showing me that. Around tea time, they're probably showing me food and beverage promotion because they know where I am in the world, so therefore they know when my propensity to buy is. So you have a right to object to this. I think this is going to be a really interesting area to look at because I think you'll see suddenly quite a shift in some online marketing practices. So if you do profiling, this is an area that you need to evaluate quite quickly to make sure that you can still get to your end goal, but potentially not in an intrusive profiling way. If you make any automated decision making on the basis of profiling, then you'd need explicit consent. So those types of loans is the most commonly used example of that. If you have basically a computer program, and it's that computer program that makes the decision on eligibility for a loan or eligibility for a rental property based upon information they might pull from various internet sources, if that's totally automated without any human involvement, you need express consent for that type of behaviour as well moving forward. There's a right of access. Has anybody here put in a subject access request or received a subject access request? No? Lydia, yes. So subject access requests are becoming increasingly more common. They tend to be used at the moment in two key areas. The firstly is the recovery of bank charges. So when people, are trying to work out if they had that insurance on their credit cards in case they lost their job and that type of thing, what people are doing is these organisations are making subject access requests to the relevant banks, because if you can't remember your account number, they can still trace you that way. So we're seeing a lot of subject access requests in that field from a financial sector perspective. The same with bank charges as well. And also disgruntled employees. So one way to get disclosure of documents earlier than waiting for the tribunal or the court process is to make a subject access request. And this is an ability for you to say, I want to know or have a copy of. They don't always have to give you the copy, but they need to tell you all of the data they process on you. And that is a very time intensive exercise to complete a subject access request. At the moment, you have 40 days from the point you receive it to give the information, which sounds like a long time, but remember, you have to search every single system you have, every single filing cabinet, every single data archive in Iron Mountain or something like that. It takes a long time. And then once you've got all of the information, you then have to work out if there's anything you can redact, anything you can take out within the rules. And so people tend to do it. They're looking for that juicy nugget of information where there might be a email conversation between two employees saying, you know that Jill Dovey, she's an absolute flipping expletive. They're looking for that, or she's really lazy, or they're looking for that type of information where they can say they've been treated unfairly. And if they can find that sort of nugget of information, it makes the employment tribunal claim come in a little bit easier, or it can get settlement a lot quicker. So there's a lot of pros for, in some situations, people putting these requests in. So under GDPR, that right remains, but they don't have to pay anymore. At the moment, they have to pay £10. They don't have to do that unless you meet some very specific criteria. And the timescale within which you must go back to the person making the request has been decreased from 40 days to a calendar month, which, trust me, is honestly not a long time to do this. We deal with this a lot for clients, and in fact we had one internally a few months ago, and it takes a long time to pull all that information together. So you were all lucky enough, apart from Lydia, whoever having received one of these, but you need to think about, do your people know what one looks like? Should one happen to come into your HR team or anybody else within the organisation? Because if you don't identify that it was a subject access request for 20 days, you've then got a very short period of time within which to still comply with that subject access request. So you should think about having appropriate policies, procedures around this should it ever happen. And as I say, it is becoming more commonplace because more people realise that it's a right that they have now. So, and some lawyers, employment lawyers in particular, are using this as a tool to get information earlier. There's also a new right of data portability. I personally think this is really only going to be of use where you maybe are changing computer systems and you want to migrate from one provider to another. I used to work for a software house, and I know they began planning for this a good 7 years ago because they saw that this was coming down the track. So they basically have to help you move to their competitor, which is slightly awkward for software providers or IT providers. The types of situations I think where it might apply in a non-business context would be things like if you've got photos in Facebook and you wanted to transfer them to Instagram or another social media platform, or if you wanted to extract information from a particular product or solution that you use online, you've got to be able to give you that in a format that means you're not reliant on that program to view the information. It has to be easily readable. So it's worth thinking about, especially if you're going to be changing providers. So the ICO has a 12-step program that they have put out, which explains what they think you should be concentrating on to move towards compliance. And very helpfully, Close Brothers have made their own version of the 12-step program, which is in front of you now, so we can look at that rather than having to deal with the visual aids. I might just steal this one. So their view is that these are all of the considerations you need to work through as part of your compliance regime. So when I am liaising with my clients, my view very strongly is that as the ICO or the data regulator, if you follow what they've asked you to do and you can demonstrate that, they're going to have very little grounds or basis on which they can really criticise you should something go wrong. So hopefully, if anything were to happen, you'd be in that Newcastle City Council type scenario whereby they say, well, you've done a lot of things in terms of data compliance and this was potentially just human error. So the first point on there is awareness. And there's a big tick in the box that you've come along today because that helps with your awareness programme. You need to make sure people within your organisation understand GDPR and in a way that they're aware of how it impacts your organisation. The second point is information, and for me this is the most important. To be able to do any of the other steps, you need to know and understand in a great deal of detail what data you have, where it goes, who has access to it, and what you do with it. So data mapping, data auditing, asset registers, all of those tools are very important and demonstrates your information gathering. There's lots of organisations out there who will help you with this. There's lots of free tools on the website. There's no right or wrong answer as to how you do this and how you deliver this. And I passionately believe this isn't something you can purely outsource and get someone else to do for you. They can do it to a degree, absolutely, but you are the people who work in that business and you understand it better than anybody else. We went through this internally. And then we did it on all of the systems. And then I spoke to my IT director and I said, I think we should do an amnesty as well. And he was like, what do you mean? We've been through every system. I know everything that's used. I said, I think you'll be quite surprised. And he was. We did an amnesty. There's quite a few people, including myself, who came forward and went, might not have told you, but I use this tool because it helps me do my job really well and helps me do all of this networking much easier than what the tool is you've given me. So it's really important as well to make sure everybody in your organisation is involved in that. And they do speak to you about the tools and practices that they might be employing with data within your organisation. The third point on there is about communicating privacy information. So you should have privacy notices on your website. And you should be very clear at the point of data capture what you're going to be doing with people's information. So it's a case of thinking about, the sort of contact us forms. Thank you very much. Type of contact us forms you might have. We'll come back to that. The contact us forms you might have, what do you do with that information? If you literally are going to add them to a database and start marketing to them, that's not appropriate anymore because you haven't got the consent for them to do that activity. So it's very important that you make sure you are telling people and being very explicit and transparent about what you do with data. Individuals' rights we've talked about, you need to understand all of these data subject points and make sure you know how they apply. Subject access requests, again, we've had a quick chat about that and you should think about how that might affect your organisation. Final point on the left-hand side is about the legal basis for which process data. Wherever possible, do not rely on consent as the basis on which you process data because consent can be withdrawn. So you need to have a little look on the ICO website and work out what the basis is for processing. The majority of you, it'll probably be contractual necessity. You'll have contracts with your clients, your employees, your suppliers, and you'll have that data and that information about them for the fulfillment of that contract. So you need your contact details of your customer, you need their payment information, you need certain information about their business to be able to assess them. We're not saying you can't collect that, absolutely not. We're just saying you need to make sure you're very clear internally and to the clients as to what your basis is on which you hold that information. When you do direct marketing, you can only do that on the basis of consent. So that's when you need to go through all of the considerations. And consent is the next point on that list. So consent has to be explicit, freely given, informed, unambiguous, and not linked to anything. I work for a hotel company, and their marketing team, understandably, don't like this because they don't want to get consent. So they have Wi-Fi because they have some public areas. So they have Wi-Fi, which most organisations have, and they wanted to say that you can use the Wi-Fi free only if you allow them to add you to the marketing database so that they can send you marketing information. You can't do that. You cannot link it to a benefit because that wouldn't be freely given consent. So again, there's a really useful guidance note on the ICO website all about consent. It's in draft. But the ICO blog has specifically said, yes, we understand consent is in draft, but we still expect you to be working towards that. And you've probably been inundated with emails from various people asking you for consent because GDPR is coming. My marketing team send me about 4 of them a day to critique because they don't like them. So they send them through. So I'm sure you'll have seen some in your both work and personal life. So if your valid consents today don't meet GDPR's requirements, you do need to get those refreshed before the 25th of May. If your current consent regime met all of the requirements, you don't need to do that exercise again. And if you are going to go back out, there are just a slight word of caution. Flybe and Honda did that, but they didn't have the basis on which to go back out and ask for consent today, so they've been fined for doing that. So direct marketing is something you should possibly have a thorough review of and read the ICO guidance before you take any steps. But you need to do this. If you need to refresh consents, it has to be done sooner rather than later, because as of the 25th of May, if you haven't got that consent to contact, you won't be able to do that going forward.
Do you need consent to telephones?
It's a really interesting question. So what lawyers love more than one new piece of legislation is 2. So there's a separate piece of legislation called the e-privacy regs that are coming out, and they deal with specifically around electronic marketing. For telephones, arguably, yes, you still do need consent, and you need to bear in mind things like TPS and CTPS, which is the telephone preference service and the corporate telephone preference service. If you have explicit consent to call them, that would override TPS, but you need to make sure you've got a way of being able to evidence when you captured that express permission, because I've dealt with lots of complaints whereby someone's on TPS, they receive a call, and then they say, why did you do that? And if you can go back, say, we telephoned you because this was our express consent form, you ticked there on whatever date to say, I'm happy for you to contact me by telephone for marketing, and that would override TPS. Children, I'm going to skip over because I'm conscious that's probably not overly relevant. You might still hold children's information if you have work experience students, if you have next of kin information or beneficiary information. So the key thing around children's data is that you need parental consent or parental authority, I should say, to manage their data. So it's worth thinking about that internally and how you manage that. Data breaches is on there. Data breaches will still happen. And a data breach, as Newcastle City Council have proven, does not mean that you necessarily have a bad or a wrong or an inappropriate data compliance regime. It just means that it's fallen down for whatever reason. And a data breach can be from, a hack, of your computer systems on the one hand to someone sending an email and using the to or the CC field for multiple email addresses rather than BCC. So you should evaluate what a data breach could look like within your organisation and how it might affect you. And if you have a data breach, you have 72 hours to tell the Information Commissioner's Office. So there are certain guidelines, again, on it about when you do and don't need to inform, but that's the general rule. So you should think about, do you have a position whereby your employees will knowingly tell you quickly if there's a breach so that you can then spring into action? So it's worth, again, thinking about your organisation and how a data breach may affect you. An employee in an organisation knowing that there's been a breach but not telling senior management, it would go from when the employee knew because they're part of the data controller organisation or the data processor organisation. Yeah, go.
You can't cold call people after the 25th of May.
You have to look at that situation and work out where you've got the information from and think about the process. So if you're just calling a general number that's on the internet, not linked to an individual, GDPR doesn't apply. So if you're calling Muckle switchboard, that's not personally identifiable. So arguably, GDPR does not apply to that. And then what you would do is you'd try and find the appropriate person, and then you'd try and do the data capture that you need to be able to have an ongoing conversation at that initial contact. So no, it won't mean cold calling will stop, but there are a lot more regulations you need to go through to be able to get to the cold calling stage. You also need to think about, when you're at events like this, you might swap business cards. And what do you do with that information? So we used to have a situation whereby it would automatically immediately go on our client information, so our CRM system, to manage a prospect or a new business partner. We're revisiting that because actually, if I get someone's business card, it's probably because they want me to call them back or me to pass it on to the relevant colleague. What they probably don't want, especially at an event like this about GDPR, is to then get a newsletter about construction. Possibly nobody in this room is interested in construction. I'm not. So do you see what I mean? So you need to think about all these types of processing and how you do it and how you control that. So you need to think about what most of my clients are doing is if they're at an event like this, they get a card and then following it up with a call or an email or whatever, and on that initial contact, they're trying to get wider consents on which to contact them further, depending upon what the relationship is and why it is. So if it's about inviting them to an event or something like that, the purpose for which they give you the card, you can absolutely use that information for. It's just if you want to use it for anything else or anything that's outside of that purpose, then that's where it would be questionable. So if you give me your card because you want me to give you a call and give you more information on subject access requests, I can do that, not a problem at all. Could probably get one of my colleagues to do it, and that would still be acceptable. But like I say, if suddenly a banking colleague rang you or something like that, that's not what you gave the card for. So I would argue, what's my basis for processing that? Because you didn't say you wanted that type of legal advice. So you just got to think it through in quite a bit more detail than I think we do today. You need to come up with a strategy and you need to understand how much risk you're willing to run. There is an argument that if you get it off just Google, and you Google a company or you get it off Dun & Bradstreet or something like that, and you can find out very easily from our website who our finance director is, who our IT director is, and who our managing partner is. If you call and speak to them and say, I got your information off a publicly accessible site, I'm calling you for this purpose, I think that's relatively low risk, as long as if they say I'm not interested, thank you very much, you don't then follow up. But it's a risk-based decision. I think in that situation, the people whose information's in the public domain like that would have a very difficult job in trying to say you've breached any of their individual rights because they've put that information out there in the public domain. If you located their home telephone number, I would think very differently about that. Because I think that's a step too far. So if if you have then profiled them against the telephone directory, and we're based in Newcastle, so if you'd found their name and then profiled them against that, that's very different because that's quite intrusive what you've done there, and you didn't have a basis on which to do that. But I think cold calling done in the right way can still happen under the rules.
What is classed as individual data? Is it so many pieces of information?
No, so it's anything. It could be anything singularly or in combination that amounts to a personally identifiable piece of information. So my employee number is 1046. That would mean nothing to you, other than I've just told you that. But Muckle would, if they said 1046, they could look at a spreadsheet and go, yeah, okay, that's Jill, done. So it can be things that are not it doesn't have to say Jill Dovey. It can be any other identifiers about me. So my Twitter handle, because it's only used by one person, that identifies me. So it's anything that alone or in combination with other information can identify a living individual. So data protection officers, we had a quick chat about this before we started the presentation. So there is a requirement for some organisations to have mandatory data protection officers where they're a public authority or they do large-scale processing. Or processing in large volumes of sensitive data. No definition of what large volumes are. Gut feel is that that probably isn't a requirement for any of the organisations here, but again, there's a guidance note, so you should check it out. And you should do a note internally as to why you think you do or do not need a mandatory data protection officer. If you do need a mandatory data protection officer, they have to have certain qualifications and there's certain obligations that they need to fulfil, which is on the ICO website. So this is the 12 steps, which, as I say, is pretty much identical to this. The last 3 that we didn't quickly touch on is data protection by design and impact assessments. That's just a procedural point that you need to build into your processes. Data protection, obviously, we just talked about. And you need to identify where you might transfer data outside the European Economic Area, because there's some additional requirements for international data transfers. And if you operate your business internationally, you can pick data supervisory authorities. But again, I don't think that's relevant. But if it is, feel free to ask me at the Q&A or grab me afterwards and we can have a chat about how businesses can work on an international basis. This is a screenshot of the ICO website. They have a very useful guide to GDPR, and down the side they've got it sort of linked in hyperlinks to the relevant sections. If you haven't been on this website, I would really urge you to take a look, because this is where all of the guidance and all of the materials are. So any questions you have, the first point of call would be this website here, and it's free. They also have a chat facility where you can ask them questions. They don't always give the most helpful answers, but at least it's there. And they have lots of tools for smaller businesses as well. They've got checklists, they've got audit tools on there as well, and there's a helpline for small businesses specifically, which might be of use to some of you. What's also really useful for the likes of me is the What's New section. They're updating this whole web page with all of the links on a regular basis, so it's worth, once a month or whatever, just have a quick look on the What's New page to sure you don't miss any changes that might have happened, because like I say, guidance is coming out and commentary all of the time. This is just a really quick overview for those of you who haven't started this yet, what I kind of see you should do after today. So assign responsibilities within your organisations, start on that data mapping process and the readiness assessment tool that's on the GDPR, because then that'll identify where you should start to look at and the considerations for your businesses. And then it is like anything, this isn't going to stop on the 25th of May. It's a continuous improvement journey like any compliance thing. So it's a case of continually assessing and making sure you're putting through policy improvements. And as you might come across something that's not maybe the best data security or the best way to address something, to just put in little improvements, it all helps. So I've got a client who had a sign-in book that was literally like a notebook, but it had everybody's name who'd been there. And I looked back, and I think it went back to 2015, and it had their name, their business, their email address, their car registration number. So it's as simple as just take that off that desk there, give it to the receptionist, let her have a page per day, because they never use that information. No one had looked back in it apart from me, who was nosy to see, what other lawyers might you have seen in the last couple of months? So thinking about little things like that and continually improving is really important.